As the economy faces a downturn, many of us are going to lose their jobs. And most of those losses, or some of those losses, are going to come through the process of retrenchment or redundancy. Today, I'm joined in the studio by Mr. Kago Mokotedi. Ladies and gentlemen, welcome to That Fine Bachelor's Law, a podcast. Mr. Mokotedi, welcome to our podcast.
Thank you, Mr. Nlegwa. Thank you to your viewers. Thank you for affording me this platform.
How are you doing?
No, I'm good. Can't complain.
That's
the
good.
Usual troubles of life.
Yes.
Yeah.
Before we get into the nitty-gritties of our conversation today, who is Kago Mokotedi?
Oh, yes. Kago Mokotedi is an attorney. Kago Mokotedi is a son. He's a husband. But I think the reason why I'm here today is that I'm an attorney, more than 10 years experience in the field.
And a radicalist.
So I qualified to be a judge. I'm no longer radical. Only my views are radical.
So you have toned down?
Seriously.
That's
marriage will make you tone down.
So that rambunctious young boy we used to see at the University of Botswana is dead and gone. Now we have a father figure, a fatherly man.
I have traded that trait when I got married. My wife doesn't allow me to express my views strongly as I used to, and also the benefit of age. I express my views in different platforms now, in the court mainly, but in the activism space, not that much.
Let's use the wisdom of age in this instance. Recently, you represented one, John Gilbert Ramontsho, in a matter that went from the industrial court all the way to the Court of Appeal.
Yeah.
As a matter of fact, there were two cases before the Court of Appeal relating to that matter. Can you give us the factual background behind Khanyaga Re Ramontsho?
Yeah, okay. So around 2018, 2019, there used to be a university called Botswana College of Agriculture.
Yes.
So they issued your Section 25 notices because they were transforming.
Yes.
They were moving from Botswana College of Agriculture to the present Botswana University of Science and Agriculture.
Of Agriculture and Natural Resources.
Ah, yes.
BUAN.
Yes. So during this transition, they adopted a new structure and they placed my client, they retrenched my client.
Yes.
To say, if we look at your qualifications, we no longer have anything to offer you in our structure.
Yes.
You then have to go home. So client was then retrenched, and ordinarily he took issue with that retrenchment. He went to the industrial court, challenging the retrenchment. He viewed the retrenchment to be unlawful. You would know, in terms of our labor laws in Botswana, a retrenchment exercise, one of the most basic principles that it must follow is the first in, last out principle.
Yes.
So that's one of the bases that he said this retrenchment is unlawful, and he took that matter to the industrial court.
Yes.
Yes.
You mentioned Section 25.
Yeah.
That will be Section 25 of the Employment Act.
Yes.
Can we get down into the legal principle or legal mechanisms that are encapsulated under that section?
Yes. So Section 25, it places an obligation on employers that whenever they engage in any restructuring that may ultimately lead in a retrenchment, they must notify first the Commissioner of Labor of that intention.
Yes.
I want to restructure my workplace for economic reasons. I want to downsize. I can no longer afford my workforce. So you notify the Commissioner of Labor first. Then you notify employees who are likely to be affected by the decision to downsize or transform. So that's what Botswana College of Agriculture did. They notified the Commissioner of Labor, notified all its employees who were to be affected by that transformation.
Yes.
Yes. So it is only after you notify those employees that you are now under a duty to consult them. You explore means and ways to avoid retrenchment.
Yes.
Okay? You must explore all other things. As
Yes.
I've said, the first in last principle would apply to say if there are two managers operating at the same level, in deciding who to retrench and who to retain, the one who got in first must go out last.
Okay.
Okay? So something strange happened in this particular case.
Please break it down for us.
Yes. So our client was employed under permanent and pensionable basis as a driver.
Yes.
He was then retrenched when an employee who was employed on a temporary basis
Okay.
was now offered a job in the new structure ahead of our client who was employed on permanent and pensionable basis. That was quite strange
Yes.
because one would have thought that an employee many years in that institution as a driver employed on permanent basis could have been well preferred ahead of an employee who had a short-term contract.
Yes.
Yes.
So, looking at this case, Ramontsho,
Yes.
you speak of the first in, last out principle.
Yes.
Is that principle encapsulated in section 25?
Yes. Yes.
Or we merely borrow it from the ILO?
No.
Or we borrowed it from the ILO and
Yes.
encapsulated it?
Yes. If you look at Botswana's laws,
Yes.
the first in, last out principle, it is inscripted in our laws.
What
Yes.
are the exceptions to the FILO principle?
Oh, yes. So, even though there's a managerial discretion on whom you can retain, the employer may factor in issues of performance, possibly. It does not simply mean that because you were the first in, you'll be the last out. Automatically.
Yes.
Okay. It's a preferred starting point, but there may be other variables. Okay?
Yes.
Let's, for instance, you may be the first in, but by reason of age, you are on the verge of retirement. So it may not be applicable when someone is 30 years old in the workplace.
Yes.
And the person who went in is almost on the verge of exit. The employer may factor in issues such as qualification. You may be the first one in,
Yes.
but because the new structure requires a particular minimum skill
or
qualification, you lack it. The guy who walked in last,
Yes.
the guy who came in last may possess that skill and he may be retained. So those are the few exceptions that is why during this exercise it's important for the employer to have your transition rules.
Yes.
How do we transition to the old structure, to the new structure?
Yes.
And normally all these variables will be listed in those rules.
I think let's now take the consultation process.
Yeah.
What is it intended for? And I want you to tie that up with why some choose to enact those transition rules. How do they assist in this process?
Yeah, so let me deal with the first one. So the transition rules or the conversion rules, as they're called in some quarters. One is purpose of transparency.
Yes.
One, which is very, very crucial. All employees, the rules of the game must be set out clearly. Okay?
Yes.
You'll be adopted into the new structure. Are you going to compete for those positions? What happens if the qualification that you hold, it is not catered for in the new structure?
Yes.
For instance, let's assume you are an HR personnel, you are an HR officer.
Yes.
With a diploma qualification. The new structure then says we need someone with a degree in HR.
Yes.
What should happen? The transition rules will speak to that. Do we let you go home, or can we find an alternative placement for you in the structure, which may not be HR,
Yes.
maybe something else which may require a diploma that you have, but not at that level. That's the first one. So the transition rules ensures transparency, because during this process, the employer has a duty to act fairly on the employees.
Yes.
Remember that the retrenchment, this is technically a dismissal.
Of some sort.
The dismissal of some sort. The dismissal, because your contract of employment comes to an end by reason of redundancy.
Should we call it dismissal, or should we just term it termination of a contract?
No,
of
it's a
employment?
dismissal, in fact, but it's a dismissal without fault.
Okay.
Yeah, it's a dismissal without fault. You are not saying I dismiss you because of misconduct. No, you're simply saying, one, I can no longer afford your services.
Yes.
Typical example, during the COVID-19,
Yes.
by reason of the performance of the company financially, I am compelled to lay you off. Go home.
Yes.
You are dismissed.
Yes.
But it is a no-fault dismissal.
Yes.
Yeah. So they must have rules that the employer must follow to avoid issues of favoritism. One. So consultation, why is it crucial and is meant to achieve what purpose? An employer has a duty to explore with the affected employees or through their union means of averting a retrenchment. It must be the last resort.
Yes.
So, you are earning 10 bula. Your employer says, I can no longer afford this wage bill because of the financial position of the company. Employees can say, look, we are agreeable that things have taken a downturn. We are prepared to take a salary cut of 50%. At least we keep our jobs. We don't go home.
Yes.
So consultation will explore those alternatives.
Yes.
It is only after those alternatives are seriously impractical, okay, that the employer says, I've explored all avenues.
Yes.
You need to go home. The consultation, employees can say, look, cut off our allowances. Let's see if the wage bill can be manageable. So for the employer to get this alternative views, he must engage in an honest dialogue with the employees. More critically, in the labor aspect, it will form part of the audience right.
Yes.
I want to take a decision to send you home.
Yes.
Can you participate? Can we have a dialogue on it? So the right to be heard.
Yes.
So it's one of the fundamental processes that an employer must undertake before he makes a decision whether to retrench or not.
Yes. I want us to go for a quick break, and then when we come back, we'll move back to Ramontsho's case, where now we talk about what arguments do you bring before the industrial court, and what was the findings of the court, and then we'll take our conversation from there. Let's go grab a bottle of water. When we come back, we'll continue our conversation. Le Mokotedi. Welcome back to our show. Ramontsho, before we went back to the break, you had laid down the background of the case and the legal basis or the legal principles that guided retrenchment. Now let's move to when you, Ramontsho, decided, or no, Ramontsho, we decided we are going to court. What was your argument in that case?
Yeah. So the primary argument was that the retrenchment was unlawful.
Yes.
Yeah.
What do you mean by it was unlawful? I think let's break it down for our viewers out there.
So the primary objection was that the first in, last out principle was not properly done.
Yes.
The second issue is that there were positions in the new structure in which Mr. Ramontsho could have been deployed at.
Yes.
Within the new structure.
Yes.
With the qualification he held.
Yes.
At the time of the retrenchment.
Yes.
And he was not placed in those positions.
Yes.
And on those bases, we say this retrenchment is unlawful.
Yes.
Now, curiously, the employer conceded on the unlawfulness of the retrenchment.
Yes.
Conceded.
Yes.
The major point of debate was what was the appropriate remedy to give to Mr. Ramontsho.
Yes.
Because the employer had conceded
Yes.
that he has not followed the first in, last out principle.
Yeah. I think before we get to the employer's concession,
Yes.
maybe let's put this into context.
Yeah.
Ramontsho was a driver.
Yes.
Then there was a new post under the new structure for a driver.
Yes.
What is the difference in qualifications that now led us to where the matter ended up? I think we need to make that distinction to say this is what the old structure wanted and this is what the new structure wanted.
Yeah, good question. So at the time of the retrenchment, the old structure, it required a driver to have a JC certificate.
Yes.
Which Mr. Ramontsho had. The new structure required a driver to have a Cambridge certificate, your BGCSE.
Yes. You are too young for Cambridge. Just stay more BGCSE.
So the new structure required a driver to have a BGCSE certificate.
Yes.
Which Mr. Ramontsho did not have.
Yes.
Yeah. So on that basis, BUAN then said, we retrench you.
Yes.
Yes. But in the conversion rules, it was possible for a person to be placed in a position that his qualification was required.
Okay.
In this instance, there were at least two positions in the new structure.
Yes.
Which required a JC certificate.
Yes.
Which he held.
Yes.
Yet denied.
Was he consulted on the possibility of him occupying or taking up those two other posts, or it was never mentioned to him?
The employer was simply not interested in offering an alternative position.
Yes.
Even the two that I mentioned, he qualified with the qualification that he held then.
Yes.
He was never placed there.
Yes.
He was never placed there. Yeah.
Okay. Now let's go back to the issue now that you were saying became contentious. What was the appropriate remedy? What remedy did you go in looking for?
Yeah. So our client sought a restatement.
Yes.
Said, take me back to work and pay me all my back pays.
Yes.
So the industrial court declined that remedy,
Yeah.
as you'd be aware. And instead, the industrial court ordered that he be compensated for 6 months.
Yes.
6 months salary.
Yes.
And certainly our client was not happy about the outcome, and he took the matter to the apex court.
Before we get to the apex court, you were looking for reinstatement.
Yeah.
Can you, in light of Section 27 of the Trade Disputes Act, break down the principles that are encapsulated therein that say, for one to be reinstated, this is what ought to be in place when the court is exercising its discretion?
Yeah. Okay. So in terms of Section 27, I'll answer it in terms of what the Act says, even the jurisprudence emanating from our courts.
Yes.
So it boils down to essentially two issues. The first one is this: has the employment relationship irretrievably broken down?
Yes.
The master-servant relationship or the employer-employee relationship.
Yes.
Has it broken down? Is it practical to restore it? Okay. So on the practicality is an issue of, is there a vacant post available to reinstate the employee to?
Yes.
And the court must determine these variables. Okay?
Yes.
So it must engage on the question of whether it's practical to reinstate. Is the employee-employee relationship in a manner that it can be restored? So that is the overriding consideration that the court makes in determining the appropriate remedy to give.
Yes.
Yeah.
Still on this principle, irrevocable breakdown.
Yeah.
Maybe let's break it down a little bit further.
Yeah.
As it relates to public institutions and private institutions.
Yeah.
Do the courts give a different consideration when assessing this, depending on the nature of the legal personality in question?
Yes, it does. The size of the employer matters.
Yes.
For instance, when you deal with a small, close-knit entity of
Like
10,
a tuck shop.
like a tuck shop, the issue of trust and the breakdown of the relationship would have much more traction than when you deal about a large public institution.
Yes.
To say, look, the fact that you're not happy with him as his supervisor, he can always be placed elsewhere.
Yes.
If the university has another campus in Francistown or Maung, yeah, he can be taken from one division to the other. So the issue of size of the employer, it's a variable.
Yes.
Yeah.
I think my question was more based on BUAN. It's a public institution.
Yes.
It is basically owned by we the people.
Yes.
As compared to a, let's say, a multinational, I don't want to mention
Yes.
names,
Yes.
a multinational supermarket.
Yeah.
Do the courts hold them differently when answering that question?
They don't per se engage on issue of ownership, only on the issue of size.
Okay.
Yeah, on the issue of the size of the employer.
Yes.
Yeah.
All right. We can now move to now. You are saying you now take the matter to the apex.
Yeah.
Apex court.
Yeah.
What was your contention?
Yeah.
Or what were your grounds
Yeah.
of appeal?
Yeah.
In relation to the judge from the court.
Yeah. There was only one ground of appeal, mainly that the industrial court misdirected itself in terms of exercising its discretion.
Yes.
We are saying the evidence led before court, a reasonable court would have naturally reached a conclusion that my client deserved to be reinstated. And we're saying by refusing to reinstate and compensate, the industrial court was in a misdirection. That was the sole ground of appeal.
Okay.
Yeah.
I'm sure when you went to the court,
Yeah.
you were not as brief as you are. For the benefit of our audience,
Yeah.
so that also when we speak in this legal jargon, we say the court misdirected itself.
Yeah.
We need to now whittle it down.
Yeah.
To say, when I say they misdirected themselves, this is what our expectation was in what they should look into, and they didn't.
Yeah.
I think if you can now break down that larger principle into those finer details.
Yeah. So to give context, before the industrial court, Mr. Ramontsho gave his evidence.
Yes.
He was cross-examined and re-examined. And then he closed his case.
Yes.
The employer elected not to lead evidence,
Okay.
oral evidence.
Okay.
They chose not to lead evidence. So one of the material evidence given Mr. Ramontsho was that he was denied reinstatement, despite the fact that his evidence that there were vacant positions available for him remained unchallenged
Yes.
at the industrial court.
Yes.
Secondly, Mr. Ramontsho was saying, on the basis that the retrenchment was unlawful, the primary remedy to consider should be reinstatement.
Particularly on your own admission as the employer.
Yes, that you acted unlawfully.
Yes.
So take me back to work.
Yes.
Matters worse is that you are not denying my evidence, you have not challenged it. So before the Court of Appeal was a court exercising its discretion, it could not have ignored evidence which has not been challenged by the employer.
Yes.
So by ignoring that evidence, which remained unchallenged, the court was misdirecting itself. And fortunately, the Court of Appeal agreed with us to say, once evidence is uncontroverted, you are duty bound to accept it for what it is.
Yes.
Because the other party was in court, ably represented, elected not to contest that evidence.
Yes.
So the evidence given by Mr. Ramontsho with respect to the qualification, with respect to the availability of a vacancy, and the lawfulness of that retrenchment would have entitled him to a reinstatement.
As I was reading through the judgment of the Court of Appeal, that was delivered in February.
Yes.
There is a mention that following his retrenchment, curiously so,
Yeah.
Mr. Ramontsho was then employed by the same employer on
a 6 months contract. Yes.
How does this now factor into your argument of
Yes.
unfairness?
Yes. It was a question actually raised by Justice Cameron. And he asked, but surely, even after retrenching this man, surely you needed him. There's something that you saw in him, that you let him go and yet retained him on a short-term contract. So isn't that evidence to show that the employment relationship is healthy and intact?
Yes.
And that you valued him, his services?
Yes.
Yeah, and surely the employer was at pains to explain that if he was not suitably placed to render service under the new structure, why offer him a contract post the retrenchment?
Yes.
So it actually worked in favor of our case to demonstrate that the relationship remained intact and his services were needed by the employer.
There was an argument that was raised by BUAN's attorneys to say the time from when Mr. Ramontsho was retrenched to now when the court is making its decision is inordinate.
Yeah.
So reinstatement would not be suitable.
Yeah.
What does our jurisprudence say in relation to the time factor when making that decision?
So the Court of Appeal has long declared a view on that argument, long before our case.
Yes.
That the amount of time taken out of work following a dismissal is not really a determining factor. Yeah. So each case will turn on its own facts.
All right.
But it was not the first time, I must confess, where reinstatement was ordered after more than a period of 4.5 years. It was not, almost 5 years. It was not the first time.
Okay.
So the period is not determinative.
Okay.
Yeah.
Let's take another short break.
Yeah.
When we come back, we'll move towards concluding our conversation. Let's go for a short break. When we come back, Mokotedi will take us through the second part of the Court of Appeal case, and then we will wrap up our conversation. Welcome back to the show. I'm still with Mr. Mokotedi. Now we are moving back. We are moving to the end of our conversation. After February 2025, BUAN decided to go back
Yeah.
to to the Court of Appeal to say, reconsider
Yeah.
the judgment that you gave
Yeah.
before. At the end of his judgment, Justice Walia gives a very scathing remark over that. Maybe take us through the reasons advanced by BUAN
Yeah.
as to why they wanted the Court of Appeal to reconsider the matter, and also take our viewer on the circumstances upon which the Court of Appeal can reconsider its own arguments as the apex court, because we expect that once it has rendered judgment, that should be the end of the matter.
Yeah. So let me start with that one. So at a general principle level, once the Court of Appeal has rendered judgment, it's final.
Yes,
So this is what attorneys would call functors of EQ.
yes.
The other principle will be res judicata.
Functus officio.
Yeah.
That's a fancy Latin word.
Yes.
Motswana ko lapeng ho batla
Oh
go
yes.
itse gore
Oh yes. So in simple word, finality. It's a principle of finality.
Yes.
Once the apex court makes a decision, litigation has reached finality.
The court has done its job.
Done its job.
It's
You
over.
cannot reopen.
Yes.
So at the general principle level, that is the principle. But there are exceptions.
Yes.
If you look at the recent Katamuru PC case,
Yes.
the Court of Appeal itself says, once we render a judgment, we have spoken. But in the interest of justice, we may revisit our judgment. That's the first one. The second one, the older cases, your criminal law cases,
Yes. The state versus COVID is an
your
example.
Kobedi, your Maue, your Monanyana,
Yes.
they laid this principle. Even post-judgment by the Court of Appeal, and new compelling evidence comes to the fore,
Yes.
the court cannot turn a blind eye to it,
Yes.
because this new evidence came to the fore post-judgment. In that instance, it may reopen its judgment.
So one would say the court will revisit its own judgment only in rare and exceptional circumstances.
Indeed. It's a very rare and exceptional procedure.
Yes.
And the courts will not lightly depart from the principle of finality.
Yes.
In Botswana, if they, I recall only one case where the Court of Appeal revisited its own judgment. Okay?
Yes.
Even the old cases, the famous Pinochet, if you know the old Pinochet,
Pinochet.
the dictator,
Yes.
where the House of Lords made a decision, it later turned out that one of the justices, in an application by Red Cross International, after the House of Lords rendered its judgment, it came to the fore that one of the justices was a board member of Red Cross.
Yes.
And I said, no, but even if you're the House of Lords, you must revisit your own judgment.
Because there is a perceived
Yes,
judgment
yes.
bias.
Yes, one of the judges who made the judgment is conflicted, and you don't declare it. The House of Lords then revisited.
Yes.
So it's a very rare procedure.
Yes.
So, and I must admit, I was quite shocked when BUAN took this step. It was a very shocking application.
Yes.
This was a employer-employee dispute about retrenchment, reinstatement.
Yes.
There was nothing exceptional about.
Yes.
Nothing exceptional about. Eh?
Yeah.
Yes.
Because if my memory serves me right, in one of these criminal cases, I don't know whether it is COVID,
Yeah.
the Court of Appeal is very clear
Yeah.
that one of the rare circumstances,
Yeah.
if there is an argument relating to Section 3 to Section 16 of the Constitution, if there is a constitutional question that arises, they can only also consider revisiting.
Yes. It's the judgment by Justice Kirby,
Yes.
as he then was in the High Court.
A very
He says,
able jurist he
No,
was.
well,
I I didn't agree with him most of the time, but I admired his penship. I admired his logic. I always said you can disagree with him on the conclusion, but on the logic. Anyway, as you were.
You can imagine. You don't agree with him, but you admire his judgments.
Yes.
That was a class on his own.
Yes.
So if something comes to the fore which contravenes the Bill of Rights, that's 3 to 15 of the Constitution.
Yes.
KB says, look, in that instance, we may reopen. Yeah. So the overriding principle is that the courts cannot lightly reopen. And the question is why? After the apex court has made a judgment, why should it really reopen it? Litigation will never end. We'll go into a cyclical litigation for decades.
Yes.
You lose, you make an application to reconsider. You win, I lose, I make same.
An application to reconsider reconsideration.
Exactly.
Yeah.
Exactly. So that consideration, any court, be it a high court or court of appeal, it must rarely revisit its own judgment.
Yes.
Once you have rendered judgment, that's it. You are done.
So what was BUAN saying? What were they arguing was the exceptionality in this instance?
One, BUAN was saying, look, the Court of Appeal in its February judgment, it took into account a qualification obtained by a client post the retrenchment.
Yes.
They say it was exceptional. Two, they say the time taken by my client out of work is just so long that ordering him to go back to work, it was disturbing their operational machinery. They were saying it was exceptional. The third one, they say, client took 14 months post the retrenchment to commence his challenge before the Commission of Labor. They say, no, look, but this time it's not indicative of an employee who wants to be reinstated. There was too much laxity in the manner that he challenged the retrenchment. So they said this thing is exceptional. The other one, they were saying, in our present vacancies, we don't have a vacant position. So if you order us to reinstate him, you are basically asking us to fire one employee to create space for him, because we have no vacancy. And they were saying all these things, they were exceptional. But surely, come on.
And what was your counter argument?
Come on, there was nothing exceptional about it. The Court of Appeal has previously reinstated an employee who was detained for 4 years. I was fine, I was 4.5 years, but really.
At Botswana Post.
Yes, Botswana Post,
yes,
yeah.
I think that is the case of Bosekeng.
Yes, Bosekeng case.
Yes.
Yes, it is, yeah. So you can't therefore say 4.5 years is exceptional when the Court of Appeal has reinstated someone for 4 years. There was absolutely nothing exceptional about it. Interestingly, the conclusion by Justice Walia, in our heads, of course, we have not complained about the rentings.
Yes.
We simply said all these complaints, they are typical of an unsuccessful litigant. Yes. There's nothing exceptional about it.
Yes.
They're just telling us the reasons why they are not happy about the judgment. Of course, Walia went a step further to characterize it as rentings. But frankly speaking, and to his defense, and with respect,
yes,
they were rentings. And I say this with utmost respect. They were rentings.
Basically, it was the last kicks of a dying horse,
yeah,
so to speak.
Yeah, I will not express a view on that. But the application was unmerited, yes, from the word go.
Yes.
Yeah.
So, as we wrap up,
yeah,
the judgment in the John Gilbert Ramontsho case, what are now its implications, broader implications, yeah, on the law on redundancy and retrenchment in Botswana?
Yeah.
Does it add any new dimension that didn't exist before, or does it clarify something that was not,
yeah,
that was there before?
Yeah. For me, the judgment merely increases the jurisprudential contours.
Wacho.
Okay. Okay. The parameters of our jurisprudence.
Yes.
Okay. They're extended by a centimeter or two.
Yes.
Boseking was 4 years. Our client was almost 4.5, gravitating to 5.
Yes.
Okay, which was groundbreaking in that context. I don't know of any judgment which reinstated an employee for a period for 5 years of
Yes.
absence.
Yes.
Okay, so for me, it has taken the jurisprudence a centimeter further. That's first. The second one for me is an issue of a wake-up call for those who have exercised public power. If you exercise public power, you have to act rationally.
Yes.
You have to act reasonably. Okay? Don't exercise public power to settle workplace scores. Okay? Don't. Thirdly, for me, the other important part of it, you will know that as a principle of our law, an appellate court will seldomly interfere with the exercise of discretion by a lower court,
Yes.
especially a lower trial court.
Yes.
Okay?
Yes.
An apex court will seldomly interfere
Yes.
when a lower court has exercised discretion, a lower court that listened to oral evidence. So, to the extent that in this matter, the Court of Appeal interfered with that exercise of discretion of a court that listened to the evidence, it also takes our jurisprudence a centimeter further. Yeah.
How did the Court of Appeal justify, in this instance, disturbing or interfering with the discretion of the court of call in this case, so that we can appreciate the value add of this judgment?
So the Court of Appeal grappled with this question, whether or not the industrial court exercised its discretion judiciously.
Yes.
And you say no, it did not. It ignored material considerations and took into account immaterial considerations in declining the relief of reinstatement in favor of compensation.
Yes.
The Court of Appeal says, no, lower court, even if you exercise discretion after listening to oral evidence, that discretion is not a wild card. It's not a blank check.
Yes.
It must be exercised judiciously, taking into account relevant and material considerations. To say, there is no how, if you are exercising proper judicious discretion, you can ignore the fact that evidence was unchallenged. 1. 2, at the time you gave the order of reinstatement, there is no how you failed to factor in the fact that even before you granted judgment, a retrenched employee obtained that qualification that he did not have.
Yes.
So a proper judicious exercise of discretion, you could have factored this thing in for you to act judiciously. Yes. So to that extent, I think it was a reminder to the lower courts. Exercise of discretion is not a blank check. Exercise it judiciously, otherwise the apex court will interfere with that exercise of discretion.
All right. Yeah. Now, as we come to the close of our conversation, maybe give our listeners a summary of what our redundancy and retrenchment law says, and offer any advice on what they should look out for next time there is such a process in their workplaces, and maybe where they should immediately rush to so that they find a recourse, like Ramontsho did.
So the first one, act timeously. The moment that you are issued with a Section 25 letter, seek advice. That's the first one, critical.
Yes.
The second issue, whatever representation you may make to an employer, make them in writing.
Yes.
It is easy to deny a verbal conversation, but you can't deny a written letter.
Yes.
Thirdly, after you are retrenched, don't wait a day longer. Declare a dispute,
Yes.
either with the Commissioner of Labour in terms of the Trade Dispute Act or the High Court. Okay?
Yes.
Then most importantly, in the representation that you make to your employer, be prepared to offer alternatives.
Yes.
The employer says, I want to retrench you. Be prepared to say, how about you dock my salary by 50%? Will I still have a place in your company?
Yes.
Yes. Because one of the things that disadvantages employees when they are facing retrenchment is the rigidity.
Yes.
Yeah, rigidity. No,
So flexibility is
the
crucial.
flexibility is crucial. Don't climb the proverbial high horse.
Yes.
Don't. Engage with the employer to say, I appreciate the economic challenges that you are facing. What if we cut allowances? Huh? Suggest all these alternatives so that in the end, when you demonstrate that the employer was not engaging, was not consultative, you demonstrate that I suggested A, declined, B, yes. Yeah.
Mr. Mokotedi, thank you for,
Yes.
for joining us.
Thank you, Mr.
We
Lema.
hope
Thank you, Mr. Lema.
probably to see you again.
Thank you, Mr. Lema.
That was Mr. Kago Mokotedi, basically breaking down the John Gilbert Ramontsho versus BUAN case and the legal principles around retrenchment and redundancy laws in Botswana. Until the next episode of that fine bachelor's law, thank you for joining us. Have a good one.